The preparation for this panel took me to the Competition Commission of India's first annual report, where the then chairman, Dhanendra Kumar, talked about capacity building at the commission, the arduous but very critical task of framing regulations. He ended the note saying he hopes that the CCI is able to play a useful role in making businesses more competitive and safeguarding the interests of consumers on a wider scale. That was a 50-page report. Cut to the current chairman's note in the latest annual report, where he detailed CCI's intervention in more than 10 sectors. In terms of numbers, the commission has so far addressed over 1,000 antitrust cases, 720 merger filings, and held nearly 750 advocacy. This was a 150-page report. I took this trip down the memory lane to bring to the fore the fact that in the short span of 12 years, the CCI has evidenced itself as a mature regulator. And I'm sure you'll agree with me when I say it's among the very few regulators in this country that's always open to discussion and has made itself available to stakeholders for dialogue. And even do so in these very difficult pandemic times. With that, it's my pleasure to invite member Sangeeta Verma, CCI, for her initial remarks.
Thank you very much, Payaswini, and thank you for the lovely introduction to the activities of the CCI. Distinguished panelists, guests, chairperson and member CCI, officers of the CCI, ladies and gentlemen, a very, very good afternoon to all of you. It is our privilege, CCI's privilege, to have all of you with us today at this year's annual day of CCI. I really hope you and your loved ones are keeping well in these trying times. My sincere condolences to those who have lost loved ones. We've just had a very stimulating inaugural session, and we are grateful to the Honorable Finance Minister for her encouragement to CCI for its market-friendly approach, focused on building a trust-based system, and have taken note of her directions to bring a balanced approach to maintaining market processes as markets recover post-pandemic. At this plenary, it is an opportunity now to look at the antitrust enforcement journey of CCI over the last about 12 years, with a view that the learnings may inform our actions going forward. We should use this opportunity to take stock of the evolution of antitrust jurisprudence and also the regulatory reforms that have been undertaken and initiated during this period. In keeping with its mandate, CCI has been enforcing the law within the overarching statutory framework and judicial pronouncements from time to time, and have been guided by the stage of economic development of the nation and market realities. Competition, as we all know, creates the best incentives for businesses to increase efficiency. It drives their productivity and it fuels innovation. But even the most ardent votaries of a market economy recognize that liberalized markets cannot be presumed to be competitive and efficient. Without oversight and necessary intervention, we could be witness to an environment where dominant firms misuse their market power to fence out competition, or cartels drive up price, or anti-competitive mergers weaken competitive structures of markets. Such distortions break the link between liberalized markets and the productivity and innovation gains that they are believed to yield. So since competition is a means to achieve these larger objectives of innovation and providing goods and services at a better price and sustaining competitive markets, this requires a synchronized policy and enforcement response. CCI, as a part of its statutory mandate, has been deploying its twin tools of enforcement and advocacy to attain the objectives of law. It is very gratifying for us to note that all our stakeholders are increasingly realizing the importance of competition compliance, and many are now putting in place the necessary in-house frameworks that would help in achieving the statutory goals in a sustainable manner. Throughout its journey, our endeavor at CCI has been to make faster market corrections, ensuring level playing field. This has become particularly imperative in the fast evolving digital markets. Technology and disruptive innovations in the digital economy are completely altering the contours of markets. They are transforming the ways of doing business and ways of communication. So on the one hand, the digital innovations are promising and they foster competition by creating more opportunities, bringing transparency with online intermediation, reducing search costs for consumers. But on the other hand, the increasingly technology-laden economy is bringing new issues and concerns in the competition policy discourse. The challenge will be to keep abreast of the developments in these markets and continue to evolve and refine the tools. This will help us make timely and evidence-based interventions and to strike the fine balance so that efficiency and innovation are not stifled while markets are free from abuses of market power. In this quest, the Commission is also proactively reaching out to stakeholders through market studies for understanding emerging market structures and issues that may have implications for competition. In the new digitalized economy, competition enforcement has to strike the right balance so that innovation is not stifled, while these markets also remain free of anti-competitive practices. A regulator's task, therefore, is much like hitting at a moving target. Markets are not static, they are ever changing. So the regulatory stance needs to be periodically nuanced, and the enforcement toolbox needs to be adapted to these changes so that the instrumentality remains fit for purpose. The Competition Commission of India has brought this flexibility to its decision-making in the wide range of sectors in which it has addressed competition concerns. With respect to digital markets within the framework of the law, in different matters, the CCI has deliberated and decided on diverse issues like determination of relevant markets in case of multi-sided platforms, substitutability between online and offline markets, etc. Indeed, the statutory framework that we have is holistic as well as futuristic. On the procedural side, also, many of the due process issues are increasingly getting settled to bring it in line with the requirements of courts. The review of our procedures is a constant work in progress. For instance, as many of you know, we have recently put out a draft proposal for revision of the extent confidentiality regime, where we have proposed the introduction of a confidentiality ring. This is in line with the best global practices. I'm sure the panelists will provide their comments formally, but we also look forward to their enriching the session through their comments and feedback. In conclusion, let me once again welcome all of you to this session today. I'm grateful that you have made time to be here with us this afternoon. I look forward to the discussions, and I'm sure that these will help us in taking forward our mutual learnings in the enforcement of competition law. Thank you very much, and all the best. Thank you.
Thank you, Ms. Verma, for your very pithy but covering a large sort of universe of issues that we hope to have a vibrant debate on today. But let me now welcome Advisor Jyoti Jindal to give us her opening remarks.
Thank you, Payaswini, Honorable Commission, distinguished panelists, ladies and gentlemen. Good evening to all of you. It is indeed heartening to see you all together after a long time in these trying times. I thank all of you for sparing your valuable time in the midst of COVID-induced challenges. Honorable member Sangeeta Verma ma'am has already outlined in a very comprehensive manner what has been a very satisfying journey for CCI on the antitrust side. On this day when CCI completes 12 years of its antitrust enforcement, I think this is a good opportunity to take stock of the journey undertaken, the milestones achieved, besides outlining an agenda for the next decade. A journey of 12 years is not a very long time in evolution of institutions, particularly a market regulator. And even this seemingly journey of 12 years needs to be appreciated in the context that this journey started in 2009 when the data explosion was taking place. The markets were on the cusp of a tectonic shift from brick and mortar formats to click and order driven digital economy. In such a scenario for CCI, most of the learning happened along the curve. And if I may say, CCI was truly baptized by fire. Of course, our law benefited from the fact that it had a late mover advantage and it was enacted based on best global templates. And in fact, CLRC, which was constituted to review the competition law, found the provisions to be futuristic and equipped to deal with the new age challenges. In this journey, in my view, CCI has been able to lay sound foundation for robust enforcement by focusing on two limbs. Firstly, the inquiry that follows robust due process and decisions that are backed by sound economic and legal reasoning. On procedural front, to provide guidance, regulations were framed, and these regulations and procedures are regularly reviewed and revised whenever required in light of experience gained and difficulties faced. For instance, the ambit of leniency regime was expanded to include individuals as well as more than 3 applicants to make it more attractive. And as has been mentioned earlier by Member Verma, CCI also recently initiated the review of the extant confidentiality regime, which inter alia contains a proposal for setting up a confidentiality ring concept and has put up the same for public consultation. The proposal aims to strike the delicate balance between twin competing claims, that is the need to maintain sanctity of commercially sensitive information and the right of parties to have full access to information to effectively defend. Presently, these issues consume a lot of time in adjudication and litigation, putting the entire inquiry process in a limbo and defeating the very purpose of correcting markets in a swift manner. And I urge the panel to deliberate on these issues and suggest measures to enable timely completion of inquiries without compromising the due process requirements. And this would help in attaining the goal of faster market correction, which is of paramount importance. Now, on the substantive side, CCI has over the years disposed of more than 900 cases across diverse sectors. And this has produced a rich harvest of jurisprudence, which is getting further refined as matters pass through various stages of appeal. Now, each antitrust case brings along specificities on account of nature of the sector, market, the way market participants interact, regulatory framework, etc., and which need to be considered holistically in arriving at a decision. Our Act, fortunately, being a modern law based on sound economic principle, provides the required framework for competition assessment to factor and give due regard to these aspects. And while deciding matters, the Commission's focus all along has been to achieve market correction through calibrated and targeted proportionate interventions. And in new age markets, where rapidly changing and evolving landscape is posing new challenges and traditional parameters are being questioned, CCI has been nimble in adapting to this paradigm shift by applying existing instruments suitably and devising new tools where necessary. And increasingly, wherever required, CCI has also been acting as a facilitator for efficient functioning of markets. For instance, in the wake of pandemic, CCI provided guidance to stakeholders by issuing advisory to enable businesses to coordinate certain activities. Honorable Minister, in her keynote address, mentioned about the need to establish a trust-based system. And I think this was also a step towards that direction. And on the other hand, CCI has always been proactive in intervening in appropriate cases on a suo motu basis without waiting for a formal information. So the period, and this period I think has also been marked by competition reforms which have been initiated by the government, and it is gratifying that new concepts are being recommended, such as settlement and commitment, which will, if accepted, help in realizing faster market corrections. This, of course, is work in progress, and we have to constantly and dynamically evolve, particularly in today's time when the digital economy is growing at a fast pace, presenting antitrust law enforcers with new challenges in ensuring that markets remain competitive, contestable, and in correcting market distortions in a swift manner. I'm sure the panel, with their vast experience, would provide the perspective on due process challenges, effectiveness of leniency regime, new challenges, and competition law reforms, and how committee of regulators can be promoted, to just name a few areas. And we also look forward to suggestions on how CCI can play a greater role in facilitating an economic recovery in the post-COVID economic arena, and what should be the approach of Commission. With these words, thank you so much, and I hand over to you to take the discussion forward.
Thank you, Ms. Jindal, for your for tons of topics that you've given to us to discuss here, and I hope you're all able to do justice to that. So without much ado, I will sort of go to my panelists now to touch upon some of the very core issues of competition law and how both the industry can do better and help the regulator do better. Mr. Ramji Srinivasan, I'd like to start with you first. I was looking at some of the numbers over the years where while in my opening sort of introduction, I mentioned the number of cases that the regulator has handled. There's a problematic trend that I noticed, at least in the last 3 or 4 years, where the penalty recovery rate is quite low. If I can just throw up some of the numbers, in 2018, it was at 2.4 crore and the imposed penalty was over 400 crores. And last year, the recovered penalty was 18 crores, while 450 crore of penalty was imposed by the regulator. I'm very tempted to ask you, Mr. Srinivasan, why are your clients such ferocious litigants? Mr. Srinivasan, you did have to put yourself, yes.
Sorry, can you hear me? Yes, thank you very much. I would like to attribute the ferociousness to 2 parts of the Competition Law Bar Association, whom I represent as the president. There is one half of the Competition Law Bar Association which represents litigants who have either filed complaints or who are defending investigations. There is another set of the bar which is supporting the CCI in its investigations, or including even representing CCI. So therefore, really speaking, members of my bar, that is the litigants, are really ones who are either for imposition of a penalty or against. So therefore, they are equally divided. So therefore, really speaking, all of them actually work for the cause of justice and really nothing more. Having said that, I think there is a fundamental aspect to your question. Penalty is the last bit in the entire process. So that is a measure. The amount of penalty levied in one case may run into thousands of crores, and it may run into a few lakhs of rupees in another case. So the recoveries in respect of penalties may depend on what stage the cases are in the judicial hierarchy, namely whether they are in appeal, is there a stay, has there been a deposit required by the appellate board, the appellate tribunal, or is it pending before the Supreme Court, and have some cases and penalties been quashed altogether? So it's a combination of all of these. But most importantly, I think, really speaking, what you are asking is, and I think, how are the results? Is it a result-oriented exercise? Have we seen the last 12 years results which are to be measured? Is it a measurable exercise? The CCI's activities since the time that it was set up and since the time that it was enabled, has there been a measurable effectiveness of competition law regime in India? Not merely, that has to be tested not merely on the strength of recoveries or penalties, but on how effectively has felt its presence in the marketplace. And I dare say that over the last decade, the CCI has been now a force to reckon with. There are more mergers that have been filed now and have been enabled by recent amendments and ease and dilution to the requirements than before. And out of the 1,100 cases, odd cases that the chairperson mentioned this morning, I think most of them relate to mergers. Antitrust enforcement, 3 and 4, will certainly be lower in number. And because they are contested, most of the time they are contested, so therefore they will have to go through the judicial process. Ultimately, we must remember that there is a huge imposition from the moment an investigation is launched until the time a penalty is imposed or certain actions are called for. There is that time gap. You have to go through that entire 3-tier process of appeals, and that is bound to take time. At this moment, we are seeing now, for example, that there is a slowdown in NCLAT, the first appellate forum, which has not been able to take up cases. We know in the last 2 years that there's been serious problems about pandemic, and several matters are pending in the Supreme Court also. So that probably explains all of this delay.
Sure. Mr. Rajshekhar Rao, I'll come to you now. Mr. Rao, while I take Mr. Srinivasan's point that the effectiveness of a regulator has to be measured by whether or not it has made its presence felt, but one of the tangible ways to be able to do so is really see the teeth in the statute, right? And the most obvious standard to do so is the penalty powers of the CCI. Is it time now, and it's been discussed and debated even at the CLRC level, that we have some sort of mandate to deposit a penalty before you proceed with the litigation, and that will deter frivolous complaints against CCI orders?
No, I think that's an important point. You're right. If one sees the number of penalties imposed and perhaps the actual recovery, there is a disconnect. But I think a large chunk of that is also because we are effectively approximately a decade-old statute, and the bigger matters are all stuck in the Supreme Court. The larger issues, let me put it that way. One way to resolve this is have clarity on a bunch of things, which enables the appellate process to work itself out. So at the appellate stage, really speaking, is where you have the ability to recover your penalty, as it were. So is it time for somebody to rethink the statutory framework and find the need for a pre-deposit, as we have in other statutes? And again, it's a dangerous place because we understand that the CCI framework, while it is obviously due process, it is compliant with principles of natural justice. At times, because of the numbers and the manner in which orders are passed, your first appeal is really the only place where you can reopen various aspects of the case. So I would think that maybe it's important to consider a pre-deposit, but a minimal pre-deposit. At least you have that semblance of recovery. And given that nowadays the penalties that are being imposed are quite significant, even a 10% deposit as a precondition of appeal becomes a significant deterrent. But I'm actually with Mr. Srinivasan on this. One could see that there is a substantial amount of fear of the process itself. And I think it's at two levels. One is, of course, of the severe consequences, both at an enterprise level and at an individual level. I don't know if we've reached a level of maturity where individuals are as scared of the process as enterprises are, but I believe we are moving towards that direction, especially in view of Section 48. That's one of the issues that is pending in the Supreme Court. But more importantly, also the fact that the time that it is taking itself is imposing a significant cost on the entity, as it were. And that is something that I would want to flag. I mean, I noticed Ms. Jinder said that 900 cases were dealt with. The question is, how many of those 900 cases were dealt with, say, in a span of 2 years or 1 year? And if the object is that you give the DG 60 days to investigate, and one understands these are complicated questions, but is there a need for a timeline? And if an investigation has gone on for more than a particular timeline, is it time for the CCI to then revisit the entire matter, call parties, put them on a table, and have a conversation? I probably have the same suggestion even insofar as penalties are concerned. Drawing a parallel on sentencing hearings, why not have a frank conversation on penalties once the CCI has decided that a penalty is to be imposed, and say, you have the ability, we've decided that you have to we're going to levy this much. Why don't you come and make an offer and we'll try and close this here. It saves us the trouble of an appeal and you get a substantial discount. I'm just wondering. So these are all thoughts that come to mind. And I guess industry is also keen. In several instances, we've seen where parties have had their appeals stuck for years and there is no closure. So it's a good time for the CCI to take a step back, flag the amount like we do in the leniency regime, and just take the same principle forward and offer negotiated settlements, which would, in my mind, encourage a culture of compliance, at least some, certainty that the CCI would be willing to look at you with a different pair of lens, as long as you're willing to comply and demonstrate compliance, and also reduces the burden on the appellate process. All of this, of course, would take us a long way if we had clarity at the highest level in terms of the Supreme Court on certain, very important aspects of law which trouble us on a day-to-day basis. Once that clarity is there, I think the entire system starts working. But of course, that's a question that Mr. Srinivasan had flagged the other day while we were just discussing it. Do you need, you want to go back to a specialized appellate authority? Do you need specialized benches? Things like that. But perhaps given the nature of expertise and the manner in which the world is moving, specialists are the need of the hour, and perhaps you will have to start, the judiciary and the lawmakers need to start looking at this very, very specifically in respect of all niche areas of practice and law.
I think all of us did agitate and mourn the loss of Compat, and it was, I think, sorely missed. It is being sorely missed by industry, so to speak. So some three great ideas, Mr. Rao, there: a pre-deposit of penalty, potentially negotiations that involve settlement, that cases that have gone on for too long, and probably re-looking or taking a fresh look at cases that the DG or the investigation wing of the CCI has looked at for too long and the report is not ready. Let me come to the third important sort of trend that has become a default, so to speak. Abir, I'd like you to come in here. The moment the CCI passes an enforcement order, is it sort of, do you all have a template ready to challenge CCI's jurisdiction?
So yeah, this is has been quite a debate wherein all the orders of investigation. So we have to understand what are the challenges that are there in courts right now. That is the writ jurisdiction.
Yeah.
So most of them do challenge the jurisdiction of the CCI, primarily on the ground that there is another regulator which is seized of the matter, / which may be better equipped to deal with the matter. And this is dependent on a case which is celebrated as the Bharti Airtel case, which was basically there was a issue between the TRI and the CCI. Now, based on that, obviously the fact situation in that case were slightly different, wherein what the Supreme Court had held was that while competition issues, CCI is the proper jurisdiction, there were certain issues in that particular case which required an expertise of a telecom regulator. So the jurisdiction of the CCI is not completely ousted. This is what the Supreme Court had said. But what happens is a lot of investigations, order of investigations gets stalled or gets challenged. And in some cases, there's a stay also which is granted on the principle that there's another regulator which is there. So let that regulator pass its decision and then the CCI should step in. Now, the difficulty with that is time is of essence in competition investigations, because especially as Advisor Jinder was saying and Member Verma was saying that we are in a digital world, everything happens very fast. So we'll deal with it. Obviously, digital economy is something that we'll deal with in certain detail. The issue is if there is a stay, then what happens during the period of the stay, even if tomorrow an order of that stay is lifted and the CCI is allowed to proceed with this investigation, substantial amount of time is wasted. So what Mr. Rao was saying is actually one of the points that the Supreme Court is doing right now, is adjudicating right now, is kind of what the IBC mechanism that Supreme Court has said, there's a judicial hands-off approach. So they have given certain parameters only on which an appeal can be there, although in a completely different context. Perhaps the Supreme Court can also lay down that under what questions can a writ jurisdiction be there. Obviously, you cannot completely take away the writ jurisdiction because they have a supervisory jurisdiction over CCI and other tribunals, but perhaps limit the issues on which a writ jurisdiction can be invoked. So that may be some guidance which may be there because of the simple fact that we have to somehow come with a balance between complete administrative law and market reality. So that's some kind of a balancing act. So the Supreme Court may be I think in one of the issues in Star India case, they may adjudicate upon.
Sure. Okay. So then in sum and substance, the Supreme Court will have to answer this for us. And until then, probably the litigants can exercise restraint and the regulator could exercise abundant caution that it follows due process and doesn't give a window to challenge its jurisdiction. Let me now go to the big sort of issue of cartels, which is a key element of enforcement. And one of the most important tools in the hands of the regulator is its lesser penalty regulations, or the leniency regime, as it's called. It was introduced in 2009, but we got the first order only in 2017. And until 2019, only 7 cases were dealt via the leniency route. Mr. Muralidhar, would you want to come in here to and speak on behalf of the industry that are the businesses extremely law-abiding in our country, or has the framework not inspired that great a faith?
Hi, Payaswini. Before kind of touching upon this question, I would kind of just spend a minute or two with respect to your previous question, which was addressed to the lawyers. And there, I would say something akin to what we have as a settlement commission when it comes to indirect taxes is perhaps something which we could have at the competition law enforcement perspective. One is where as soon as an investigation is initiated and even before an adjudication is made, the parties can be given a right to kind of go to the settlement commission kind of a body, if CCI can set up one such, and make a full disclosure. And depending upon the disclosure and the cooperation that the parties do with this kind of a settlement commission, there can be some leniency shown in terms of penalty and other consequences. So that's one suggestion that I had from an enforcement perspective. Now coming to the next question which you posed directly to me. One of the key things that we have seen is where the Competition Commission has been quite sensitive to the requirements of the time that we could see during the onset of the first wave of COVID. This was last year. So one of the key areas, like speaking for, say, industrial gases and medical gases industry, the onset of COVID required that, the industry had to ensure that medical oxygen is, available at sufficient levels across the country. So that required a few horizontal transactions between competitors in the market. So CCI was quite realistic with this requirement. So this was where, in fact, they reached out to the stakeholders and relaxed certain conditions. Of course, here is a case where since medical oxygen is price of medical oxygen is regulated by NPPA, but nonetheless, CCI did come in to kind of give that comfort to all the players to ensure that, the key thing is to take realities into account and make sure that the product is available across the country. So we had a situation where we were getting orders under the Disaster Management Act to make available some product from one location to another location to a competitor and things like that. So we had to immediately bring in enforcement. In fact, speaking for all the operators in medical gases industry, to begin with, each one was very comprehensive or apprehensive in terms of whether to implement these orders which are issued by DPIIT under the Disaster Management Act, because to implement that, then that could kind of contravene the provisions of the Competition Act. But the minute these relaxations happened, so more or less all the major operators, they, I think, kind of went, gave appropriate training in terms of compliance with the competition law requirements, made sure that whatever interactions amongst the competitors is purely to kind of satisfy the requirements of the orders passed by the DPIIT in terms of making sure that medical oxygen was available across the country. So in terms of awareness, yes, today competition law is one of the key parts of any compliance as far as corporates are concerned. It's taken very seriously. It's almost, speaking for, say, US MNCs, it's almost on par with the US FCPA training. So I would say competition law is, of course, given all the seriousness. In fact, but for the relaxation, we would have had a serious problem. In fact, not just during COVID-1, in fact, even during COVID-2, where the demand for medical oxygen literally went some 7 to 8 times more than what it was at the peak of wave 1. So I think the swift action in terms of which the Competition Commission gave us the relaxation. Second, the quick training that each of the major players gave to their respective teams, that helped a lot in terms of taking care of this.
Okay. Thank you for taking us through the practical interactions that you've had with the regulator in these COVID times. But I would like to go back to my question on the leniency regime of the regulator. Mr. Srinivasan, how have your clients reacted to the CCI framework on lesser penalty regulation, and what is it that they'd like the CCI to do to strengthen it, to inspire confidence, or let's say more, non-compliant participants to come forward and confide in the regulator?
So you need to unmute.
Thank you, Raj. Thank you. That's a very important question, Payaswini. I think it's been well recognized globally, and including our regulator, that a leniency regime, a robust, effective, and a transparent leniency regime, these three are very important factors in the leniency regime, will go a long way in doing two things. One, apart from creating an awareness in the industry that you, if you do commit, that you have a chance of coming clean, and therefore that will be to your benefit. The other is that it enhances, it's a multiplier in the hands of the CCI with limited resources, any agency. It's so difficult to actually come across and bust a cartel or some such thing, or any anti-competitive activity. So therefore it takes resources, it takes time, as we know, for various reasons. And sometimes this is abused by industry, some parts of the industry, or people who don't want to comply, because they think we will simply beat the system by the delays and therefore we will recover. And at the end of it all, if we know that there is going to be a penalty, then it's worth it. So therefore our economic cost-benefit analysis weighs in favor of breaching, delaying, hiding, and sort of not cooperating. So therefore a leniency regime, if it is suitably and made attractive, will help go a long way. Now, biggest players that you will see in the recent times are ones who've been exposed to the leniency regimes globally. There'll be very few of them who actually have an awareness from an Indian industry standpoint. So therefore, what does that mean? That only means that two things. Global players know how heavy penalties can be, and therefore it will actually wreck them. And therefore it's a good idea for them to go ahead and come clean, make a clean breast of it, and come out with a leniency and race ahead because they get the benefit if they are the first to call out. The other is that the moment the leniency happens, and countries across and regulators across have adopted what is called very clear demarcations. So therefore it's transparent. So a person in an industry must know that if I were to come clean and confess, I will be granted. And the second person will be a second marker and he will get this. Those regulations we already have. And therefore there might be in recent times some confusion on whether or not that is applied strictly and therefore in a consistent manner or not, with two recent decisions where some remissions were granted to everybody. So that may be one ground for people to say that even if I don't, if I were to come and confess later and maybe a bit of it, I may still get the benefit. So therefore, really speaking, the incentive for a person to come and confess must be maintained, and the person who comes in last must not get that benefit. If that is maintained, there may be other reasons. It may also be because the CCI feels to make it popular at this stage, it is necessary to give this remission. So the idea is, remember, the idea is not for the regulators across the world to go and become policemen. They aren't there to go ahead and wield the danda on everybody. The idea is to create an awareness in the market that if you don't follow the rules, then you will be dealt with very strictly. And if you come clean, then you may get some remission. So I think that's the idea of a leniency. We've had, and I would those three factors that I mentioned, if they are applied uniformly, transparency, consistency, and also an advocacy program, which makes it known very well to people in India also, will help go a long way. If, and this is one more important thing, if courts were to impose penalties and say we will not interfere with the award of a penalty, or that you must deposit 50%, because we've now got 10% as a de facto rule in the NCLAT or the appellate forum. So they say 10% or give, earlier it used to be an FD, and now sometimes it's a mixture of FD or a deposit. So therefore that by itself may not be enough. So provided that the investigation is so thorough and the audit is so good, and that will come only with experience, and there is no just ex facie of a flaw that the appellate court is hard pressed to ignore, I mean, it can't ignore it, so therefore it has to state. So provided this exercise, the groundwork is done very well and the CCI orders are so speaking and so clear, it becomes very difficult for an appellate court to then interfere. And that's happening. Earlier, they used to stop it on procedural grounds. Now that's shifted. They are no longer stopping. Appellate courts are less likely to interfere on matters. They now go on merits of the case or maybe some fundamental law. The only thing that you will find, Payaswini, which you hinted in the beginning was, why, and Nabir also mentioned and Raj also mentioned, was this, that people are now finding another way to go and interdict the process, which is to file writ petitions to challenge jurisdiction. I think that's unfortunate. That's the only thing that courts and writ courts, if they're a little slow, then you will restore the jurisdiction back to the CCI. The fear comes back. The danger is very large and looming, and that will encourage, therefore, compliance with law.
Sure, Mr. Srinivasan, if I can take your response and concise it in few words. You're just asking the regulator to come up with very robust orders and then get far more stricter. Mr. Rao, please come in here. There's another important element that both Member Verma and Advisor Ms. Jindal touched upon, and it's still at the consultation stage. So I guess it's going to be fruitful, your discussion on that, and that is the confidentiality ring proposals that the regulator recently put out. I'm made to believe that in some sort of informal sense, this has already existed, but now the CCI is looking to institutionalize it. Could you sort of give us your experience on, the ways and cases where the regulator has allowed for such rings to be formed? What has the experience been for your clients, and also sort of how can this process that existed so far in an informal fashion, when formalized, can be made robust?
Well, I think it's a step in the right direction. This is that classic, confrontation between the need to be informed of everything that is against you, as opposed to while protecting the person whose information is being shared. And that balance has always been tricky. I mean, we've many times run into black pages, if I could use the word, because there were pages and pages which had just redactions and nothing more. And it becomes difficult when you're trying to defend a position. And the CCI, of course, has always found ways to kind of, to give you some of that information in some form or the other. But there are several instances where, you run into that brick wall of confidentiality. I think the advantage with the confidentiality club, and it's probably slightly new as far as the competition jurisprudence is concerned, but as far as IP jurisprudence is concerned in India, it's been in place for a while. And what it does do is, I think it takes responsibility down to each of the individuals who are part of that ring. And somewhere along the way, we then have to realize that while we are representing clients, we are also acting as professionals. And I think what it will eventually do, and if regulated properly, and when I say regulated properly, therefore, we all have to then wake up to the fact that confidentiality is something that's serious. We have to ensure that we don't breach and stay within that Lakshman Rekha. And it also enables counsel to counsel communication to get better. Counsel to CCI communication to get better, and a lot of the issues that you face at a hearing can get resolved outside the courtroom. So from that perspective, I think it's a brilliant move. We've had at least one experience where there were multiple parties. We all went into a hearing expecting a lot of opposition, and suddenly in 30 seconds we were out of the room because the CCI said, "We'll do this," and it seems to be working fine so far. I guess the question is of numbers and how do you ensure compliance? That's going to be a practical challenge, but like I said, each one has to answer to himself or herself, and that's how it's going to play out. What I guess the issue that I want to flag is, what about cases which have been pending, say, since 2011, 12, 13, and you have, confidentiality issues being raised today? The regime has changed, the regulation has been amended. There needs to be some clarity on that. Am I going to be governed by the same standards that existed pre-amendment, or is it going to be, the existing standard that's going to apply to me? Things like that. So those I think are practical issues, and I'm sure they'll be dealt with on a case-to-case basis. But
and I'm sure, like you said, the regulator will fine-tune its framework as it gets more experience, in a number of cases. Let me now shift focus from leniency, confidentiality, recovery rates, jurisdiction, to the hottest topic in the competition or antitrust world, not just in India, but globally. and that's the digital economy debate, and how the CCI can keep the competition healthy and yet not kill innovation in markets. Mr. Acharya, I've let you be quiet for very long now. Weigh in here. You're sort of representing, the digital economy. You're a digital business. This is, we'll come to the cases that are sort of in courts in just a bit, and talk about the principles there. But just last year, the CCI put out a report for the e-commerce sector, and directed you all to self-regulate and maintain a slightly transparent process. How has that worked out? What are the changes that you as business have done since last year to make the regulator comfortable?
Yeah, I think, am I audible? Can you hear me well?
Yes.
Yeah, great. Thank you. The market study is something, is a good report, I would say, by CCI. And that has come through a lot of discussions with the sectorial people in the sector and also experts around. The CCI has painstakingly got into each of these issues and tried to understand things. In a way, I felt the industry consultation is something must for a regulator to adapt to the changing business ecosystems and all of that, to understand also like how these businesses function. And from that perspective, I would say it is a great step. I think most of it, this specific to this e-commerce report, consisted to those sectors which is dealing with consumer goods and accommodation services and food services. So interestingly, this is not the only sectors which doesn't make the e-commerce, right? And there are other sector. Digital economy means like there are a lot of other business which is done online through digital media. But however, I think this is a great step, and this mostly try to like make people to understand like what are their moral obligations. So it's a self-regulatory governance, whereas people could really like refer this as a reference document and try and figure out what they're doing is right or not. It really helped and prompted many in the e-commerce side, where the in-house councils have being their obligation of bringing more awareness about competition law compliances within the organization, really have caught hold of this report and then started talking about compliances within the organization. There are some gap analysis, there are some awareness sessions. I think that really helped in terms of amplifying the competition law awareness within the e-commerce sector, I would say.
Okay, all right. But any specific measures that you took basis the CCI's report that you could sort of give us some flavor of?
I would rather put it generalized statement as to how abuse of superior bargaining power is something that was very important, because what was directly looked into was the vertical agreement, where these agreement terms are in favor of the participants or not on the platform. Right, that is one important aspect that I would say has been really relooked at by parties. Now we were compliant, I would say, but at the same time, it also gave us more benefit in terms of pitching the position as to what cannot be done with the company folks within the company.
Sure. Okay.
And other aspect is the regulation of data, right? So while the report did not take any position on the data, but the report clearly send a message to e-commerce, our digital economy, our digital businesses that hey, you will have to maintain transparency while you collect data and while you use data, so that make sure that there is absolute transparency is provided. I think most of these cases, when it comes to parity, price parity, platform conditions, all of that is the emphasis provided was mostly on the transparency, so that people who are participating in the platforms
Yeah.
should know what they are doing. I think this is something greatly helped. I probably think most of this digital started following those. I know there is there's a beating stick also on enforcement flexibility, which is also very clearly communicated in the report that
Yeah.
Those conducts could be dealt under the abuse of dominance as well as vertical agreements also, because
Sure.
you cannot escape such act which can lead to such abuses.
Sure. That was very insightful, Mr. Acharya. Abhi, let me come to you on one of the hottest cases that's going on in court today about on a messaging platform. And the only reason I'm mentioning the case is to talk about the principle of the matter, which the regulator hinted in its telecom report, telecom sector report earlier in the year, that it does want to look at privacy from the competition law lens. Where are you on that debate? Where are you on that debate?
Hello, am I audible?
Yes.
Yeah, so let me just check what the CCI said in the order for investigation. What they have said is, we are not into the right of privacy as a fundamental right or otherwise, which is presently before the Supreme Court and various other courts. What we are interested, or what the CCI is interested in, the order for investigation. Let's keep one thing clearly in mind. There's no final order yet. It's just an order for investigation. What is the order for investigation? The order for investigation is all this data which is so collected, and there's a new term which has come in, data police, monopolies, data police, etc. Whether all these data collection and data analysis and basically commingling of the data with their parent companies has certain effect on competition. So while it's the same, maybe the same conduct, but the lens with which both of them are seeing is completely different. One is obviously we do not have a privacy regulator as such, but let's, for example, just presume that there is a privacy regulator, and also appreciate the fact that privacy is a fundamental right, which the state must guarantee. Even assuming that, but that is on a principle of my right of privacy qua the users or the citizens. What the CCI is interested in is that because of the lack of privacy, you have such access to large amounts of data or data sets, which you can then analyze for your own benefit. This is where the CCI is looking into the matter, which is only the order of investigation. Now,
Sure.
what has to be there is let the investigation happen. So right now, obviously, the Delhi High Court has said that you can proceed with the investigation, and the division bench is looking into it, which is again going back to the administrative law principles and committee between regulators that we spoke about earlier. But the lens with which both of them are seeing is completely different. And as practitioners, what we see as readers of competition law, this is something which not only India, but their German counterparts have also done. And this is something which perhaps the CCI is well equipped, because what the CCI has said, not only in this order, but in other telecom surveys and their public stances, etc., that this is a non-price competition mechanism. So we always look at competition as pricing, because what is the traditional way to do business is that I buy something from you and I give some money in return. This is non-price. I am using WhatsApp services and giving my data in return. What you do with the data is something, maybe a privacy concern, definitely, but also a competition law concern. And this is what the CCI wants to investigate. So I think the CCI is perfectly justified. Again, time is of essence. So we'll see how the final report comes.
Okay, Mr. Srinivasan, let me come to you. World over, regulators are struggling with that, probably with the same entities, with parent entity. Interestingly, the German authority used violation of data regulations to say that there is an antitrust violation. Now, the EU Court of Justice will have to answer that. In India's context, the fact that we don't have a data protection regime, isn't CCI our only recourse when it comes to abuse of data by dominant entities?
I will sort of calibrate my answer a little. And I don't think that even CCI believes itself that it is the only authority to regulate data privacy or whatever else. But I think the point that Abhi made, and I'll take a cue from that, actually speaking, is this. If we were to step back a little and we look at what is it that this data is all about. This data is an asset in the hands of a business entity. There is another company who's competing who has lesser data. There is a third company which has even lesser. So therefore, the question is that like any other asset of which you have in abundance, maybe far more than the rest of your competitors have, because of the nature of the asset, there are 1.3 billion and you've covered most of them and they're already on your platform. It's a bit like land, for example. The largest colonizer or developer has the largest land banks available in a particular area. So therefore, the tests provided by the Act itself says, are you, by virtue of your resources, strength, power, money, assets, presence, all of those, your balance sheet by itself, are you in a position to have an economic effect greater and larger than the others? And are you using that to oust? So that's what they are considering. It's not a question of whether or not there is data privacy being maintained or not being maintained. I think that's probably the wrong, probably misunderstood issue. The question is, by virtue of money bags, and some people said during the taxi cab, you've got so much money as an asset that you're throwing it, deep discounts, and therefore you are now going ahead and taking over all the smaller players who don't have that much of that particular asset. They may have taxi cabs, but they don't have the cash. So therefore, it is really in that nature, an asset. So therefore, by virtue of the use of something like this over which you have, and therefore, and part of that is also network elements, externalities, and so on. So how to break it, deep discounts. That's part of the study itself. But they will spawn a lot of questions. So if you do allow the CCI to be able to investigate all those elements, I think the fact that you are in control mostly of one set of data which the others don't have access, and are you using that and therefore abusing 4, and therefore enacting violence, a violation of 4, is the investigation. They may come out and say, no, it's not, it's made available. And Microsoft had to go through all of that when it had locked in. So therefore, they had to go into investigation. So had Intel. So therefore, they had to get into an investigation. The results may have varied in jurisdictions. But are you saying the CCI has no jurisdiction? I think the jury is still out on that.
Okay, Mr. Rao, weighing here, when, the Competition Act in India was introduced, it was probably we didn't think that we will see the digital boom or the digital markets explode so much. And probably that's the only thing that everybody's talking about, whether from the glorious investments that we have seen, private equity make in India, or whether it is regulating these businesses. So is there number one is there something in the act or the statute or the regulations that needs to be built in to circumscribe what CCI can or cannot look at? Second, it's very hard to prove, let's say, the theory of harm in the digital market, right? It's more of an economist question, but I'd sort of request you to weigh in on that. That you can see in brick and mortar markets that the harm is very tangible. Here the harm is difficult to spell out, given that users are getting the service for free. The user experience is great. So how do you sort of, as the regulator, establish the theory of harm? And finally, is it then prudent for the regulator to look at data usage and not data collection by dominant entities?
Okay, I think that the statute is largely a principles-based statute. So to that extent, it does, according to me, arm the regulator with enough teeth should the need arise. As Mr. Srinivasan says, the question is, yes, can you jump in straight away, or because you have the ability to take a prima facie view, you wait for the results on the ground. And it happens at 2 levels, right? The same principle that we look at from an economic standpoint in terms of financial institutions. If you're too big to fail, so the similar principle, if you look at consumers are getting great benefits because you can sit at home and probably you don't have to step out for anything that you need. But please remember that the same consumers relied on a huge section of the economy, comprising of small scale industries, individuals, kirana stores, etc., etc. And that's that critical balance, because while the ones who run those kirana stores, and there was at least one in every locality, and if you add the numbers, and today if you look back and you do just a statistical analysis in terms of how many small enterprises cater to the needs of the many, vis-a-vis how many large enterprises cater to the needs of that exact number. And is there a problem if the balance is so top heavy that tomorrow if one of these decides to go under for whatever reason, then are we left scrambling? I mean, I think that's, taking a point from what Muralidhara was mentioning about oxygen. Suddenly you have a surplusage of demand, and you don't have the last mile connectivity. And which is why perhaps, at least in the first round of COVID, it was the small kirana stores which took care of people. It is only later when government got its act together, the big e-commerce systems found their frameworks, managed to kind of get around it. And then of course now we have what I should say is a good mix. On the harm to consumers, I think that takes us to that other question of which consumer are we looking at? Are we looking at it from the perspective of the consumer, or are we looking at it from the perspective of somebody who's a consumer as well as a provider? And what are the numbers there? And again, the same utilitarian principle of as long as the consumer sitting at home is happy, should it really matter from the regulator's perspective? Because at the end of the day, the regulator also says, I'll play a light touch approach, let the market work itself out. And as long as there is no impediment to supply and demand, and that is working itself out in accordance with normal market forces, then yes. But and I think it's important for the regulator to step in from time to time and at least watch with a hawk's eye, because the more power that is concentrated in the hands of a few, the more the possibility of abuse. And because of the nature of the digital economy, opacity is another big problem. I mean, I think the CCI can keep trying to catch up, but technology will keep moving ahead. And unless the CCI also has the ability to equip itself with the same tech tools to keep up with the digital economy, we may be found wanting. So I think my only advice probably is that the CCI adopts the standard big brother approach. Let's everybody do their jobs. And as and when there are concerns, again, what is a concern? Is it a small section of the population, losing their right to livelihood? Is that a concern? Or is it that section of the population being wiped out of the framework results in the possibility of extremely large harm to the larger section, which today seems to be happy sitting in their respective houses? And I think that's that balance. So to answer your question, I'm quite keen to see if there's an amendment to Section 3, and whether, for some time at least, you may want to incorporate an exception saying digital economy not to be touched. We look at a regulator who looks at digital markets exclusively for some time, notwithstanding the fact, and it's a limited time frame. That's one. Number two, could Government of India, to encourage innovation, at least for some time apply the exemption route? So Section 54, it's something that's rarely used. And just taking two steps back on the leniency regime, like you said, offer a VDS and say, fine, you guys operate in a space where we can't get in beyond the point. We are giving you an opportunity to come clean. And after that, we will go deep inside and evaluate every little aspect of your lives. And if then you are found wanting, then heavens will come crashing. But that balance, again, please remember, if you take action against an institution that is too big to fail, do you do more harm to the economy than good?
Okay.
I think that's it's a tricky space, but I feel that there is enough, at least as far as the statute exists today, to give you it has all the tools that you need to address any situation that emerges, at least at the present and perhaps in the forthcoming future. The only place where I see a disconnect is your tech ability to keep up.
Okay, I'm sure all these points are well taken by the regulator who's listening in. We are just completely out of time. I had at least 5 more questions on my list, but I'm prompted that we need to give time to the next session to start. So I'll take one last question that has come to us from one of the viewers of this session. And Mr. Rao, I'll put that to you. I'm asked that given the intrusive nature of a CCI investigation and the recognition by courts that the powers of the DG are far more sweeping, then the powers of investigation conferred on the police under the CRPC, is it time for the CCI to revisit the prima facie opinion standard and require a more robust view at the threshold stage? Though I might add, in my offline conversation with some of the CCI members, they did point out that initially, let's say in the public procurement cases, where I think CCI took a very myopic view in some of the cases, that, if there is, the bid coming at the same price, CCI would order a investigation. That sort of standard has now been expanded to include look at the agency that is putting out that tender and some of the other factors that are a reality in the public procurement process. But broadly speaking, do you think that CCI standard at the prima facie stage needs to be relooked at?
I think it needs to be higher. In fact, the Supreme Court makes it quite clear. It's prima facie, but prima facie has definitely dropped over the last couple of years. At least that's been my experience. Especially because there is no mechanism under the framework of the Act, notwithstanding that limited space of the possible penalty imposed on a person who comes with unclean hands. It's a minor rap on the knuckles. It's very easy for somebody or for a bystander to come and make an allegation with absolutely no material. And the CCI has, at least on some occasions, perhaps called upon, the CCI adopts two approaches. One is, of course, unilaterally looks at that information and then decides to proceed ahead. This is apart from its own suo motu exercise. But there are instances where the CCI has called the opposite parties, heard them, and then proceeded. I would think that the CCI should perhaps, unless the CCI has credible information of its own, or the information has such unimpeachable evidence which warrants a prima facie opinion to be made, make the informants do their homework. And that's really what I would think is the benchmark of a prima facie order. More often than not, what happens is somebody comes in and throws, a stone, it splashes, and somewhere along the way, some of those splashes stick. But the objective is not that. The objective is to come with a file which sets out credible material, tells the CCI that the individual has done his homework or her homework, and explains to the CCI from an economic standpoint why the CCI's intervention is warranted. So the point I think I'm trying to make is the CCI perhaps should also start looking at a benchmark in terms of a number. Pick your battles. Not every complaint which may have an impact of say 5 crores, 15 crores, 50 crores on the economy is something that the CCI needs to inquire into. There are enough avenues in the law for that. But if it's something that has an impact of 500 crores, 1,000 crores, 5,000 crores, we're looking at being a $1 trillion economy. Please look at the issues from that perspective. Something that affects society at large, as opposed to something that affects the informant or his peers. So that's what I would think is the threshold. And make them work. Make the informant work before you call upon opposite parties. I think that's really it. The threshold needs to be much higher.
That, I think one of the it is that anonymity is not going to be a default. With that, I have to wrap up this because I'm by the convener to do so. I will invite Mr. Leader to give us excluding remarks and probably to some of the concerns that have been raised during the panel.
Thank you, Payaswini, and thanks a lot, all the panelists. It has been a very, very insightful and I must say a very frank discussion on a large number of issues. So before I conclude, I would like to perhaps touch upon and give CCI's or perspective on some of the points which have been brought forth. Coming to the first point on the recovery of penalties. So there are a couple of things to be kept in mind. First of all, any order passed by the Commission of Contravention includes cease and desist directions, and of course, in appropriate cases, penalties are also imposed. So, of course, market correction is out of the cases. That is what not has been stated. And apart from that, when we look at the recovery of penalties, of course, what also has to be seen is that what is recoverable, and a large number of cases being at different stages of appeals Of course, they are not recoverable by CCI at this point of time. And a lot of good suggestions have come forth, and which have also been reflected in the CLRC report, that how this process can be expedited, be it in terms of having a specialized bench or a deposition of a bigger penalty percentage upfront. And all these suggestions, I think, will go a long way in making progress, because ultimately penalties need to be recovered and matters need to reach finality, in fact, in a time-bound manner. I think the message which has come very clear is that time is the essence, and delays actually do not benefit anybody and impose a huge cost. And now coming to the issue of jurisdiction, and where there are overlaps between CCI and other regulators, I think it is very clear that CCI, being the market regulator, has an overarching role which cuts across sectors. And of course, for the competition issues and anti-competitive conduct, it is best placed with its experience and the powers which have been given under the Act to look into these issues. Of course, sectoral regulators also have their role carved out. So while these issues are being discussed, I think what is of utmost importance is to have a very harmonious relationship between, and a consultative approach between regulators, so that this aspect can be looked into in an efficient manner, and everyone can concentrate on their role without losing time and resources on these kind of conflicts. And fortunately, our law also provides for these enabling framework, and CLRC has also suggested for further strengthening of the same. Now, coming to leniency applications, I think the experience so far has been quite heartening, and the way we have been receiving applications, in fact, many of them are at different stages of investigation or inquiry, so they are not known in the public domain. So I can assure you that these in fact are a reflection of the faith shown by the industry, and definitely we need to work on this regime, because going forward this is going to be an extremely useful tool to burst cartels. And we have taken note of some of the suggestions given here, including the ones which of course CLRC has also suggested, like leniency plus regimes and other suggestions. And it is very heartening to hear from the industry that the advisory issued by CCI provided the much required clarity, and they were able to proceed based on the direction which was provided by the Commission. And that is, again, as I mentioned, a trust-based approach which Commission believes in, and we hope that it will be followed in true spirit by the industry. Now, coming to confidentiality, then from the comments which have been made, some of the comments which we have received, I think it appears to be a step in right direction and should take care of a lot of procedural issues, and at the same time address the due process requirements of the parties, and will go a long way in expeditious conclusion of inquiries. Now, coming to the issue of data, I would not like to comment on any specific cases because these matters are sub judice, but at the same time, I would like to point out that the recently concluded telecom market study brought forth the aspect of data in the context of competition in digital communications. It emerged from the study that privacy can be a parameter of non-price competition, and low price data protection can lead to a standard legal category of exclusionary behavior, which undermines the competitive process. And the study brought out the importance of competition law in the regulatory toolkit governing data. Increasingly, I think internationally also, a lot of authorities are looking at as data as a competition metric, and that's where CCI's role comes. Like has been said about the digital economy, and some very interesting suggestions came. I don't know to what extent some of them are implemented, but